I'm going to turn it over to Britt from Prudenti Law, and she'll be chatting with us about advanced directives and power of attorney. Thank you so much for being here, Britt.
Yes, hi, my pleasure. Hello, everyone. Thank you for joining us today. We're here to talk about advanced directives and powers of attorney, a little bit about who I am and how I came to you today. I am Britt Berner. I'm the managing partner of Berner Prudenti Law. We are a law firm with 4 locations, 3 in Suffolk County, as far out as East Hampton, and then in Manhattan as well. And in partnership with the Shelter Island Public Library, who puts on great programming, I'm here periodically giving information about estate planning, elder law, and estate planning being for people of all ages, elder law really focusing on as people age and become in need of care. And basically, we're here today to talk about advanced directives and powers of attorney. So, I want to point out that when we talk about these are documents that every adult should be thinking about. And when I say adult, I mean once you hit the age of 18 years old. Um, at the age of 18, you no longer have someone who is in charge of making decisions on your behalf. And therefore, you have to start to think about who might step in and handle things for you should you become incapacitated or even if you just need assistance. And we're going to talk about what those documents are. We very often have people who have children who are heading off to college, who are now in a position where they are legally adults, but still rely on their parents for many things, and sometimes have their parents actually they sign a power of attorney or healthcare proxy, giving these authorities to their parents. We use it all the way through to when somebody is elderly and maybe we're concerned about a loss of mental capacity through Alzheimer's, dementia, or other cognitive impairment. And these documents can also be used in those circumstances to make sure that somebody can step in and make decisions. So these documents are incredibly relevant regardless of where you are in life. As Sarah said, there is a chat function, so feel free to type your questions into the chat. And when I finish, I'll go through the chat and answer any and all questions that have been placed in there. So when we talk about advance directives, they are documents that are signed in advance of needing them that direct how you should be cared for. Advance directives, the first one that I like to highlight is a healthcare proxy. A healthcare proxy is a document that says who should make medical decisions for you if you're unable to make them for yourself. Now, it's very important to realize that when you talk to a doctor and the doctor says, here's the treatment we're proposing, these are the pros, these are the cons, they have to be sure that you have the mental capacity to understand the pros and the cons and come up with a decision about whether or not you want that treatment. I point that out because someone may have the capacity to say who would make decisions for them, but not have the capacity to make the decision. So, for example, I may know that my parent or my child or my friend or my spouse is the person that I would trust to step in my shoes and make decisions for me if I couldn't make them. But I may not be able to say, I understand all the pros and the cons, and I have the capacity to make that decision. So it's very important to realize that capacity is very nuanced and it can be fleeting, right? You could have capacity to do one thing and not another. So I always say, if somebody says, do they have capacity? I always say the full sentence is, do they have capacity to do what? Right? That's really what we're asking. The healthcare proxy is specifically talking about making medical decisions. If you go online or you look at the New York State Department of Health website, or sometimes you may have seen this if you've checked into the hospital or a doctor's office, there's a healthcare proxy document that is a standard New York State issued document. It is a 2-page document. It has several pages of instructions leading up to it, but the document itself is 2 pages. It's often printed double-sided, and it says who makes those medical decisions for you if you can't make them for yourself. You have to name one person at a time. So let's say somebody has two children. You cannot name child one and child two. It has to be child one and then child two. There has to be one person serving at a time. That's according to New York State law. And you will put that person, your name and address, that individual's name, address, and phone number. And then there's also a section that says optional on the document, and it talks about whether or not your agent is able to make end of life decisions for you. And you have to actively write in that section, my agent knows my wishes regarding end of life treatment, and that you're allowing them to make those decisions. You then sign the document and date it in front of two witnesses who are over the age of 18, not the individuals named in the document. And then you have a valid healthcare proxy. Now, in our office, we don't use the New York State standard form because very often our clients want to put more than two people. The form only allows for an initial agent and a successor, whereas sometimes our clients have 3 or 4 people that they want to list in a hierarchy in case the first ones are unavailable or unwilling to act. And so we use a separate document that complies with the law. But the New York State form is perfectly fine. I signed my first healthcare proxy as I was going in for a surgery to remove my appendix, and I wanted to make sure that the individuals that I wanted to be listed were listed should there need to be a decision made. Because realize a lack of capacity could be long-term, like a cognitive impairment from a dementia or an Alzheimer's, something that's unlikely to improve, or it could be temporary, like if someone is under anesthesia and therefore unable to make a medical decision, and that could become necessary. And so that capacity, you can regain your capacity and lose it again. It is not something that is a one and done determination. The healthcare proxy document is incredibly important because it allows you to keep control in that you are saying who should make those decisions. Now, if someone is in a facility, either a nursing home, a rehab, or a hospital, and a decision has to be made for them, and there is no document in place, there is a law called the Family Healthcare Decisions Act. This has a default for who will make medical decisions for you if you're deemed incapacitated, unable to make those decisions. And the top of that list is an agent under a healthcare proxy. However, if you don't have an agent under a healthcare proxy or a court-appointed guardian of the person, then there is an automatic list. Your spouse will fall at the top of that list, your children, your parents, your siblings, and it has an on, and it actually gets down to a friend on that list if there's no one else to make the decision. But you want to make sure that you are saying who makes the decision and you're not relying on a default. For example, if you have 5 children and they can't agree on a course of action and you have not signed a healthcare proxy, all 5 of those children have the same level of control, and one of them might have chosen something very similar to what you would have wanted. But because you have not empowered them over their other siblings, they're not able to have the loudest voice in the room. And very often it is just the loudest voice in the room that wins out when you have so many people who are empowered to make the decision. So it's very important to make that and not rely on the default. I want to point out that I said there needs to be 2 witnesses over the age of 18. And very importantly, it's not a doctor. It's not a lawyer. Now, it can be, right? Very often I sign a healthcare proxy with my clients and I'm one of the witnesses. However, this document does not require anybody to be anything other than over the age of 18 and not listed in the document. When I signed my first one, it was a nurse in the emergency room and the person who was sweeping the floor because it was about midnight when I was signing it. So any person it can be. It does not need to be notarized. You can also list on that document if you are an organ donor. Along with that document, we often do what's called a living will. A living will is a document that, in very general terms, states what your wishes are regarding end of life treatment if you are in an irreversible state with no reasonable expectation of recovery. I very often describe this to people as someone who is maybe in a coma or completely unable to come back from whatever it is that they have, according to what the doctors say. Now, in that case, the living will can say something along the lines of, if I'm in an irreversible state with no reasonable expectation of recovery, then I allow my agent to withhold or withdraw treatment. This can list out cardiopulmonary resuscitation, CPR, kidney dialysis, cancer treatments, antibiotics, etc. Now, a lot of people want this document in place because they want it to be clear that their agent has the authority to withhold or withdraw any and all treatment if they feel that that's what's in the best interest, and also states that they wish to be kept out of pain, even if it may hasten death. There are certain medications that are given to keep someone out of pain that may slow the breathing, etc., and could make it that that person does not survive, and that's okay according to the document. Now, some people will say to me, well, it's such a general document, it's not even legally enforceable. It's not, no one accepts that. And I do think it's very important to state your wishes because, again, these are being looked at a time where you do not have the ability to state your wishes. And also, it's a good peace of mind to the individuals that you've named as agent that they are following your wishes. I have had many children or family members of clients say to me, it was a very hard decision to make to withhold or withdraw these specific treatments, but because we had that living will, we understood that this is what that person would have wanted. And it made it a lot easier for us to make the decision that we think was best for them because we had this document in place. So I do encourage people to look into it and decide if that's something they want to sign. Now, to be clear, you can give the authority to withhold or withdraw treatment in the healthcare proxy without elaborating in the living will, but many people like to sign both. Another document we often sign is a HIPAA waiver. HIPAA is the Healthcare Information Portability and Accountability Act. It is the law that gives you protection over your private healthcare information. So, for example, if you go to the doctor, you have a right of privacy over those medical records. If you go to the pharmacy, you have a right to speak in quiet consultation with the pharmacy tech or the pharmacist about your medications. You have a right to privacy over your healthcare information. And what the HIPAA waiver does is it waives that right to privacy, and you can list certain individuals. So, for example, if you do have 5 children and only one of them is serving as your healthcare proxy, according to the law, but you want there to be a free flow of information to all 5 of them, you could sign a HIPAA release that allows information to be released to all 5 of them, even though one is in the decision-making position. And that often makes people feel more comfortable because they know that everybody has access to the information when trying to make decisions. This is also a state form. It does not require any witnesses. It does not require a notary. You sign it and you date it, and that's it. You can also put a duration of time. So you could say for 6 months or for a year or for an indefinite duration, this document is in place. Those are documents that I often sign with clients or that clients can sign on their own. But one document does require the doctor. In New York, we call it a MOLST form, MOLST, Medical Orders for Life-Sustaining Treatment. This is a form that you get from the doctor, is signed by the doctor. It is issued by the New York State Department of Health, and it's actually on a hot pink piece of almost cardboard feeling paper. And it is specifically to list your wishes in more detail than the general healthcare proxy and living will. And it includes who's your surrogate decision maker, like your healthcare proxy. It can include when you should be brought to the hospital, when you shouldn't be brought to the hospital, when you should be cardiopulmonary resuscitated, the chest compressions, when you shouldn't. It can include DNI, do not intubate orders, because remember, medical orders for life-sustaining treatment, these are physicians' orders. This is not just me saying, this is who I want to make decisions. This is me in consultation with my doctor or my agent in consultation with my doctor, making determinations and getting them down on paper. If somebody's at home, if they're in a rehab or a nursing facility, and then they're brought to a hospital, the document goes with them. It can be changed at any time. You're not locked into your decisions. And there's actually a place on the document that you can say when it was changed and how it was changed. But it's very important because that document can really guide how someone lives out the end of their days. It is considered appropriate for somebody with a terminal diagnosis or with a determination that they're likely to, or it's possible they may die in 2 years or less. So this is not going to be a document that healthy child going to college or healthy young adult going to college is going to sign with their doctor. This is going to be for a later in life individual, and it is specifically done with the doctor. Medicare pays for an appointment with the doctor to fill out this document, but very importantly, it is an office appointment. It is not supposed to be a physical. It is just a moment for you to consult with the doctor and the doctor to fill it out. I highly recommend that my clients talk to their doctor about these documents later in life, because I had a client who was in her 90s. She actually did not have anyone that she felt comfortable naming as a healthcare agent. So she didn't have an agent. She had her wits about her completely. She had her capacity, but she knew that her health was failing. She was in her mid-90s. She signed a MOST form, and she actually died in her home accordance to the instructions on the MOST form as she had wished. And so they are regularly accepted and a really good idea. The healthcare proxy document is not a medical order, and it is a legal document. And so you'll find that EMTs, for example, will take the healthcare proxy if they see it, and they're trained to look on the back of the front door and on the refrigerator, and they'll take the document and they will transport it to the hospital with the individual, but it is not their responsibility to read it or to determine who the agent is. So there was actually a lawsuit in which the spouse was there and she was the listed healthcare agent, and she was trying to direct the EMTs to take someone to a specific hospital. And in the end, the spouse was brought to the hospital as determined by location. And in the lawsuit, the EMTs won because it was found that the EMTs are not responsible to interpret legal documents. Their responsibility is to stabilize an individual and transport them for further medical treatment. Very often people are at home on hospice care, and if somebody's at home on hospice care, that MOST form is very important. The MOST can also serve as what we used to use all the time before we had the MOST form in New York, which was the non-hospital DNR. So a DNR is a do not resuscitate order. Again, we're using that word, which means it's a document that's signed by the doctor. It's the doctor's orders. And it is a DNR is usually done when somebody is in a facility. It does not last forever. If you go home and you come back, you would need to have the doctor sign a new DNR if that was still the way you wanted to be treated. And it's only referring to cardiopulmonary resuscitation. So it's not referring to all those other forms of treatment. It's not referring to intubation. It's referring to the chest, traditional CPR with the chest compressions. So when somebody is at home, they would have a non-hospital DNR, and that would last longer than the hospital DNR, and it often used to be put right above the person's bed, so it was very clear that they were not to be resuscitated if 911 was called. Now we find that a lot of people are using the MOST form in place of that because it does cover that in the form as well. Those are all of the healthcare related documents that we like people to think about. Then I'll shift to the power of attorney, which is financial in nature. I always say that the power of attorney is talking about the business of your life. So a power of attorney can talk about regular bills and expenses being paid, your rent, your mortgage, your maintenance, your utilities, your phone bill, your food, all the regular parts of your life. But it can extend to business dealings, retirement accounts, etc. Now, what's very important to know in New York is that we have a very specific power of attorney law that has a specific format that the document must take. And if you want a power to be given to another individual, you must list it in the document. So, for example, if you want your agent to be able to act on your behalf when it comes to a business decision, you must specifically give that power to your agent in the document. Now, if anyone has ever signed it, you know that the way the document goes is there's a big warning on the front page that says you better really trust this person that you're naming because you're giving them a lot of power. You then have your name and address, and then you list the name of the person or persons that you're naming as agent. You can initial a box that allows them to act independently of each other, which is very often done for logistical purposes of just getting things done and only one person having to sign off, but also because we've found that a lot of banks and institutions don't like having two people that have to act together because then they feel they can't police it. So you'll list your agents. You can list successor agents as well, those that can serve if the first individual or individuals cannot. And then there's that grant of authority. A through O, we initial at letter P saying we give all the above listed powers. Many people choose to use that catch-all. Others will pick and choose the individual powers, and it really just depends on the circumstance, what your situation is, who you're naming as agent, what you need them to do on your behalf. You can then indicate if you're also going to be giving gifting powers. Gifting powers in the power of attorney context in New York refer to any transfer of assets out of your name. So it could be from you to a trust, from you to another person, from you to your spouse. Anytime it's just straight transfer of assets, not payment for goods or services, that's considered a gift. So if you want your agent to be able to create a trust on your behalf and move your assets into that trust, you would need to give the gifting authority. Later in the document, you would actually have to more specifically lay out, these are the gifting authorities I am giving. I'm allowing my agent to move assets into another person's name. I'm allowing my agent to move assets into their own name. I'm allowing my agent to create a trust and move assets into that trust, etc. You'll also put other modifications in. You can say if your agent should be compensated and how they should be compensated. You can say what other powers can they open a bank account on your behalf, close a bank account on your behalf, change beneficiaries, etc. These are all different authorities that can be granted through that modification section. You then will sign the document and date it in front of a notary who will also sign and date it. And then you need two witnesses, one of which can be the notary. So basically the notary and then one additional person. Now, for those that have mental capacity but have the physical inability to sign a document, the power of attorney law was changed in 2021. And one of the things that it did in New York here was that it gave us the ability to sign on behalf of someone. So I had a client who was unable to hold a pen in their hand because of an illness that they had. So it was a physical inability. However, they were able to tell me who they wanted to be the agent and understood the powers that they were granting. So I was able to be in the room, have that person say what they wanted. I was able to sign that individual's name. And then I had an additional notary and witness who notarized and witnessed my signature. And it was my responsibility to make sure that I was following the wishes of the individual. And we have done that, and it was accepted when then the agent had to go and act and do business on that person's behalf. So that was really huge because a lot of people do have a physical disability or inability to sign their name or to sign a document, but that doesn't mean that they lack the mental capacity to do so. And so this was very huge in terms of decision making for those with those physical inabilities. Once the document is signed with the appropriate witnessing and notarization, the agent being named in the document also has to sign the document in front of a notary. Now, let's say that I'm naming individual A as my agent and individual B as my successor. A and B do not have to sign when I sign. I can sign it and tuck it away in a drawer. But now let's say the time arises that I need someone to step in my shoes and act on my behalf. Person A can go and get that document, sign it in front of a notary, have it notarized, and then can start using it. And then maybe down the line, person A has to resign. It might be time for person B to act. Person B can sign it and do the same thing. So it's not time limited as to when the agent has to sign. But that being said, other people feel very comfortable just having person A and B sign when they sign, just to make sure it's a fully executed document and there's no questions. All of these documents that I've talked about today can be amended or revoked as long as you have the mental capacity to do so. So, for example, if you want to revoke your power of attorney, you have to send a written and notarized revocation document to the person that you had previously named, telling them that their authorities have been revoked. And then once they know that they've been revoked, they can no longer act under the document. It's not enough to just sign the revocation and never send it, because you have to put them on notice that they no longer have those powers to act. Same with the healthcare documents. You can change your mind at any time as long as you have the mental capacity to do so. I'm going to stop there. If there's any questions, please feel free to put them in the chat, and I'd be happy to answer them. I'll just give that a minute. The other thing I want to point out about the power of attorney document is that many people come in and feel very strongly that their document be a durable power of attorney. So durable in that context means that it's in effect now and it remains in effect should someone become incapacitated. In New York, the form that is laid out as the shell of the document from the state is no longer referred to as a durable power of attorney. It just is titled power of attorney. However, in the document, in the body of the document, it actually says that the power of attorney is durable unless the document says it's not. So all powers of attorney in New York are durable unless they specifically say this is not durable. I can tell you in my entire time practicing, I've never seen a non-durable power of attorney. They're incredibly rare and they're mostly used in a business context, not in the estate planning context like we're discussing today. I often also have people refer to a springing power of attorney and asking for that. This is a power of attorney that states in the modifications that the document is only in effect if someone's deemed incapacitated by a doctor. I generally like to stay away from those because I find that it is very difficult to get a doctor to state that somebody lacks the capacity to make their financial decisions. There's also a lot of gray area, and there might be time where somebody wants or needs assistance, but they're not to the point where they're deemed incapacitated. And so sometimes the springing power of attorney doesn't actually give us the authority that's needed in many cases. So I would rather someone sign the document and not hand it over to the agents to sign to hold it off from being in effect, rather than have it be springing and dependent upon the opinion of a physician. I'm just going to wait another minute or two and see if anyone writes a question in. Okay, it seems like we don't have any questions. Well, I thank you all for joining us today, and I thank the Shelter Island Public Library for all of the great programming that they put on and for having me. These estate planning, advanced directives, and powers of attorney are incredibly important documents for adults from 18 to 118. And it's really important that you think long and hard about who you're naming and what powers you're giving over and understand what you're signing. So I encourage you, especially with the power of attorney, to speak with a lawyer and to understand what it is that you're giving forth and you are uh, what you are getting yourself into, what authority you're giving out to others. So thank you all and happy holidays to everybody.